Hello, everyone. I'm Lady Booth Olson. I am so incredibly happy to be here today in the capacity not only as the wife of this man who was just given enormous accolades, very generous accolades, by Roy Black, but also with two people who have come to be part of my family, Sandra Stier and Kris Perry, as you just were told, two of the lead plaintiffs in our case back in 2009. We regret that the other two plaintiffs, Jeff Cirillo and Paul Katami, are not with us today, nor is David Boies. He could not be with us, but we have Ted and his harem. And in some ways, I suppose you could say that it's an all-female event, since Ted has been anointed an honorary lesbian by Kate Kendall and condoned by Maureen Dowd in a column in the New York Times. I'm delighted to be here today, and I want to thank Tom Healy for inviting us all, and for all of you for being so interested, because this case has meant so much to all of us. We've been living and breathing it literally for 6 years. I'm a lawyer also. I was trained as a tax attorney, but I never realized how boring indeed my field was until I came into an issue that affects so many people in their hearts. And I became literally married to this case, as well as to Ted. I was so proud of him. I've never been more proud than 2009 when he decided to do this, contrary to many people's expectations. But I don't want to talk anymore about that. I want to get you in the mood. I want to take us all back, because you're here to hear about that case. Thank you. I want to take us all back to that day in January 11 of 2010, when our trial began. The case was announced in 2009. The trial began in 2010, January. The first interesting thing about that is that when the case was brought, Chief Judge Walker of the Northern District of California decided to set it for trial, also against a lot of people's expectations. A brilliant move, subjecting this ignominious form of prejudice to trial and presenting witnesses from across the country and from across the world, Cambridge, Harvard, Yale, testifying to interesting issues that are germane to all of us in our lives. And the trial should be accessible to all of us, and we hope it will be someday, about the history of the marital institution, about the history of prejudice against gay and lesbians, about the harm that denying gay and lesbian citizens the right to marry. All of these critical questions were subject to a 13-day trial. Fascinating. First time it had ever happened in federal court. Again, I felt so fortunate to be a participant. I would have done anything to help, even fetch sushi at lunch, which I did. That was my primary role. But I sat on the front row of the courtroom, and I want to take us all back to that day. Kris and Sandy, I want you to assist me in this. I want to set the mood for everyone, what it was like to walk into that court on that momentous day. And I'm going to have Sandy and Kris read from their testimony. Ted took the testimony of Kris and Sandy. The first two witnesses were actually Paul and Jeff, and they did a beautiful job. But Kris and Sandy, Ted approached them and began to ask them the key questions in this case. What is it like to be gay in America? And what does it feel like to have been denied this incredibly vital right? So Sandy, I'm going to ask you. Kris, I'll ask you first. You were the first. I'm going to switch chairs for you. Kris was the very first plaintiff. I'd like to set the scene by having her read the answers to the questions that Ted, you asked so beautifully that day on January 11th of 2010. Ted had asked Kris to explain what it was like to be gay in America, and he asked, what would it be like to have lived in this country had you grown up knowing that you would be given this right to marry as a child?
I believe, for me personally, as a lesbian, that if I had grown up in a world where the most important decision I was going to make as an adult was treated the same way as everybody else's decision, that I would not have been treated the way that I was growing up or as an adult. There's something so humiliating about everybody knowing that you want to make that decision and you don't get to do that. You know, it's hard to face the people at work and the people even here right now, and many of you have this, but I don't. So I still have to find a way to feel okay and not take every bit of discriminatory behavior toward me too personally, because in the end, that will only hurt me and my family. So if Prop 8 were undone, and kids like me, growing up in Bakersfield right now, could never know what this felt like, then I assume that their entire lives would be on a higher arc. They would live with a higher sense of themselves that would improve the quality of their entire life.
I don't know if Kris was aware, but the courtroom, I'm sure you were aware that you could have heard a pin drop. There was silence in this packed room with reporters in the back 3 rows. The other rows were we were packed like sardines. I was in the front row, and I was crying, and I was feeling self-conscious. I reached down and got a package of Kleenex out of my briefcase, and I pulled it out, and Christina Shockey was sitting next to me, asked me for one, and then somebody next to her, and the package of Kleenex passed down the row in the front row. I think one of the things that was so compelling, too, about that moment was that you didn't seem as if you were even aware there was a soul in the room except you and Ted. It was really fascinating, Kris, and I want you to talk about that a little bit and tell people how you were thinking and feeling at that moment.
You know, we had practiced talking to each other quite a bit, Ted and I. Nothing that we had ever said to each other in preparation was what I said in court that day, but there was a great familiarity and ease in the relationship because we'd spent so many hours together before trial. And the advice that Ted gave us as we got closer to trial was just look at me, don't look at anybody else, don't think about anything else, just look at me and you'll be fine. And I got to that seat and took the oath, and I did exactly that, and I think that's why it felt as possible to be clear and specific about what was most painful for me about growing up gay in America, was this sense that everybody knew I couldn't have what I wanted, but I still had to hold my head up high every day. And I don't think I'd even really made all those connections until trial. And so there's something about a very pressure-filled, high-stakes experience that, you know, you can reach a new part of yourself, I guess, under that. And that's really what happened.
It drew you to a higher state in some ways. Sandy, you too. I hope you're enjoying this. I'd like Sandy to read what she said that day, right after Kris. Sandy testified, and there were several paragraphs before this, but Sandy really started talking more about the next generation.
Well, it took us so long to get married that now I have to wear reading glasses because I've aged quite a lot since we started this whole thing. Okay. I said, marriage has a fundamentally different connotation in our society. We are not business partners, and we are not social partners, and we're not glorified roommates. We want to be married. It's a different relationship. Being married would provide me with a sense of inclusion in the social fabric, and I think I would feel more respected by other people, and I would feel like our relationship is more respected, and I would feel like I could hold my head up high in our family, and our family could feel proud. But on a different level, you know, as a parent, you are always thinking about that other generation, the next generation, because for us, they're in our house. You are constantly thinking about the world that you are and the society that you are in, and what are you doing for them? Are we building a good world for them? I really want that. So I really do think that about that generation and the possibility of having grandchildren someday and having them live in a world where they grow up and whoever they fall in love with, that it will be okay because they can be honored and they can be true to themselves and they can be accepted by society and protected by their government. And that is what I hope for. I hope for something good for Kris and I, but we are big, strong women. You know, we are in a good place in our lives right now, so we would benefit from it greatly, but other people over time, I think, would benefit in such a more profound and life-changing way.
Thank you, Sandy. Another beautiful moment in the trial. And what's interesting there, too, is that this was the conclusion of Sandy's testimony. Everyone was waiting for the other side to get up, Chuck Cooper and his team, to get up and cross-examine Sandy and Kris. And they said, "No questions, Your Honor." That was the conclusion of day one of the trial. Ted, I know you're feeling a little emotional over there. I'm sorry I did that to you now. But I would love you to talk about that a little, because they weren't going to dare dwell on this beautiful moment. They didn't want the opportunity for that emotion to continue. I think that's part of the reason that there were no questions.
Well, I think that Kris and Sandy captured, with their testimony, the emotion that we felt in that trial. This was a record-breaking event. It had never happened before. We felt that we were going to put discrimination on trial. We were going to prove what it was like to live in California, to be denied the right to marry the person that you loved. The California Supreme Court had upheld the constitutional right under California law to marry someone of the same sex. That was in May of 2008. And then the voters in November of 2008, the same election that President Obama was elected president, took away the right of Kris and Sandy and other Californians to marry the person that they loved. So this was not too far away from those days. And every other case like this had been presented to a judge with motions and citations of cases and material out of textbooks and things like that. This is the first time that we had the opportunity to put live people on a stand in front of a judge in public in California or anywhere, and to give them the opportunity to talk about their lives and to put flesh and bones on discrimination. We did not know how it was going to unfold, as Roy Black would tell you, that you never know what's going to happen in a courtroom. And we had practiced in the sense that we had spent some time with the male plaintiffs, Kris, Jeff and Paul, and we had spent some time with Kris and Sandy going through the fact that they were going to testify, and we had some questions that we thought possibly could be asked by the other side in the form of cross-examination, but we did not prepare the questions and the answers because we wanted it to be genuine and from the heart. And so we wanted to have a conversation in that courtroom from the hearts of our plaintiffs. And so that's what you heard a little bit of. And it was as if we were the only people in the courtroom when I was talking to Kris or when I was talking to Sandy. And it was as if everybody in that courtroom was a witness to a private conversation about who you are, when you discovered and felt that you were gay, what it's like going through life. Kris and Sandy have been raising 4 boys. That's the reference that Sandy had to they're all around us. If you ever have a chance to see the movie that HBO made out of this, and I don't know if you're going to get to this lady, there's a movie called The Case Against 8 that took film right from the beginning of this case and produced it into a documentary called The Case Against 8, which HBO put into theaters and on television in June. You'll be hearing more about that movie, and I guess a little bit more today. But what happened in that courtroom was real life. It was real discrimination. It was what it was like for individuals to live in a place where they were not treated the same as their neighbors. And that's what we wanted the judge to hear.
Since you've introduced this idea, I think I'm going to ask Kris and Sandy to talk about this. You mentioned that they have been raising 4 boys. They have been a family. They've been together for 15 years plus. They pay their taxes. They have a mortgage. They are upstanding citizens. I think you pay your taxes. I actually don't know.
We asked them, lady. We were not going to. We were not going to put them in the courtroom if they hadn't been paying their taxes. We checked them out pretty thoroughly.
I think it would have come out by now, the amount of examination. They have been under the microscope. But I'm building to this question, and I'm sort of jumping over 4 years. I wanted to take you through the 4 years. A lot of it is not interesting. We ended up with this procedural issue that took us back and forth through the California Supreme Court, a little foray into the California Supreme Court, twice to the Ninth Circuit Court of Appeals because of this procedural issue I think most of you know about, the standing issue. And that was eventually how the case was resolved, and Judge Walker's opinion was reinstated in a sense. But the 4 years was fortuitous for many reasons. I think it's kind of an interesting fortuity because for among many other things, it allowed America to kind of catch up to the issue. Ted and David were doing a lot of media, Hollywood, with Modern Family and all these wonderful shows to bring a human face to this heretofore abstract issue of same-sex marriage. All of this was taking place during those 4 years that it took for Windsor, the DOMA case, and our case to get to the Supreme Court, and now here we are today. And we'll be getting to the status quo today later in our program, but I'm jumping to March the 26th of 2013 when our case actually did go before the Supreme Court. And I think that we have been so sensitized to this. I hear words, Ted has an expression, words that clang. There were several questions during the argument. One of them came from Justice Alito, where he began to talk about, oh, well, this is kind of a new concept, isn't it? And maybe, it's only since 2003, the first state was Massachusetts. It's only a decade. And he used the word social experiment. Talk about clanging, right? Here these two are. They're family. How did it feel for your family to be called a social experiment?
I remember that well because if it clanged for you, it clanged for us too. And 2 of our boys were in the courtroom that day, and they weren't sitting next to us because you don't really get to choose where you sit in the Supreme Court, something we learned. And I just thought of them, I thought, oh, that must have really hurt them because that's like calling them a social experiment. To say that our kind of family is a social experiment, then what are they, an experiment? I mean, they're not. We're not an experiment. We're a real family with real kids and a real life, and it's not an experiment at all. It's a real life. And so I felt like it was a way to minimize us and reduce us to a less than status, which is something that we have been fighting against the whole entire time. And it was happening in the Supreme Court. We were being told that we were less than by a judge.
Incredible. Luckily, Justice Kennedy, on the other hand, adverted to the fact that 37,000 children in California alone are being raised in same-sex families. And I think he said it in a very loving way. What about the voices of the children? And that was an interesting thing. Kris, you were about to say something about the social experiment point, I think.
Sandy said it well, but there was also something, a kind of interesting thing that happened a year or so after that day in court. The day that we were there was the day before Edie Windsor and her team went in. And then later on, we were at an event and we met Edie Windsor and we were having coffee with her. And she said...
Describe who Edie Windsor is.
Edie Windsor is the plaintiff in the DOMA case, the repeal of DOMA case that was argued back-to-back with ours and ruled on back-to-back with ours. And it was the repeal of restrictions on same-sex couples being able to have federal benefits. And so she was successful with her attorneys in repealing that while we were repealing the one in California, the ban in California. So it was really nice to meet a plaintiff in another federal lawsuit that had also been very successful. And really the combination for us of being able to get married made it possible to then enjoy the benefits that she was successful in getting for all of us through the repeal of DOMA. Without this ban in California being removed, it wouldn't do us any good at all to have DOMA repealed. We would be still living in a state like you are here in Florida, and it's really heartbreaking that the benefits are available to other United States citizens right now that live in states with marriage equality, but here in this state you can't access that, and it's so unbelievably unfair. We are all very impatient with the process and would love to see it all resolved very soon, but the story about Edie Windsor is that we went to have coffee, and we were talking about our days in court, and what did we think, and how was it, and she said, well, I was listening to the radio on the day that your case was there, and they were playing back the audio of the judges and what they said, and when Kennedy said, but don't we have to listen to the voices of these children, these 37 some odd thousand children in California, she turned to her attorney and said, we're going to win. And it was really a very beautiful thing that we didn't know that because we didn't meet Edie then, but she really believed that moment was the breaking down of the wall between, not having and having, because the children really are the reason to do better. That's why we were plaintiffs in this case, was that not our children, but all the children that have been born in California since the ruling or growing up there today shouldn't grow up feeling the way I did. That I don't have I don't get to be happy. I don't get to feel equal. I think that was more motivating than our own marriage, which is, motivating enough, but really fortunate to have both things be true.
Lovely. To take you to a little bit less intriguing point, but nonetheless I think important to bring out. In our trial, the other side had presented two witnesses. The major, it was winnowed down to two. It started out as 14, and if David Boies were here today, he'd explain what happened to those other 12 witnesses. And Ted, you want to chime in and explain, since he's not here?
I will. When the is it okay now?
Please. This is really
It's like this way at home too.
no, it isn't. You can see why I'm squirming.
May I speak now? The judge, when he announced, I think it was in August, we wanted to start marriages right away. We felt that we were going to win this case, and the judge says, no, I'm not going to enjoin the enforcement of the California Constitution. People in California went through that once before, earlier in the history, when the mayor of San Francisco allowed people to get married, and then the California court said no, he didn't have the authority to do that. And Kris and Sandy maybe should talk about this, but they did get married, and then they received a letter from the authorities saying, well, you're not married, and the judge didn't want people to go through that in California. He wanted to, we'll have a trial soon. I'll give you an early trial date, but we're not going to change the status quo in the meantime. He is a very, very thoughtful, careful judge on every single issue. And so he gave us 3-4 months to collect witnesses, experts on, a lady alluded to this, experts on marriage, experts on political science, experts on discrimination, the damage that's done by discrimination, psychology, raising children, people from all over the world. And then what happens in a case like this is that you identify your witnesses. Your witnesses have to prepare a report of what they are going to testify about, and then the other side gets to take depositions to get to question those witnesses under oath, and in many cases and videotape, to see what the testimony is going to be like. So our witnesses, our highly professional witnesses, submitted to depositions and cross-examination from the other side. David Boies, who would be here today, except he's in the midst of a trial in Washington, D.C. that's been going on for 7 weeks, and has got, see one of his partners here, 2 more weeks. David works harder than anybody I've ever known. Is just the finest trial lawyer, except for he's tied with Roy Black. So David would be here, but he probably wouldn't have, he's too modest to explain what happened. As David and other members of our team cross-examined their witnesses, and one by one, their witnesses decided, well, they didn't actually have to be in California in January anyway. Maybe they had other things they'd rather do than to be cross-examined in court in public by David Boies. And so they came up with various different excuses, but we knew what it was all about. In fact, one of them later said, the idea of being cross-examined by David Boies, and Bill Gates and other people have experienced General Westmoreland. He's famous for this sort of thing. Know what it's like to be cross-examined by David Boies. But if they'd had something really solid to say, like the witnesses on our side, we weren't afraid of them having being cross-examined, and they weren't worried about cross-examination because they had studied the subjects that they were testifying about. They knew what they were saying. They couldn't be shaken from their convictions because they were true convictions that came as a result of a lifetime of studying the field and submitting peer-reviewed papers and things like that. Now, if that sets it up for the two that
Thank you.
Two that remained that actually did come forward and testify.
The one that I think most people have read about and know about, and if you've seen the case against, how many people have seen the case against State, the HBO documentary? Then you know what's to come. It's David Blankenhorn, who's a big personality. He has a master's degree in Victorian cabinet making, but nonetheless was qualified as a witness for marriage equality, or against, I should say. We actually love him now because, and I'll tell you what happened next, is that he had written a number of books, and He was admitted somewhat reluctantly as the expert witness, but Chief Judge Walker did allow him to testify, and he wanted to testify that children do best with a mother and a father. He ended up testifying instead, after being taken through numerous questions and lots of depositions, and then on the witness stand, many hours of questions by David Boies. He ended up testifying that two adoptive parents raising a child from birth actually, on some outcomes, outstrip the biological parents in terms of providing protective care for their children. Number two, he likewise acknowledged that he was not aware of any studies showing that children raised from birth by a gay or lesbian couple have worse outcomes than children raised from birth by two biological parents. Number three, he then conceded, this is coming from a pretty good book, by the way. Maybe I should show everyone the book, since this is a book fair.
Take the yellow thing off so they can see the cover. No.
Are you giving me instructions now, Mr. Olson?
I've got this name tag that says author on it.
Redeeming the Dream. Ted Olson. I read it on the plane. It's actually pretty good. Number three.
You
Sorry,
admit
Val.
it. You read it before.
No, he wants to make sure and clarify that. Number three. Here we are. Drum roll, please. Now that I've destroyed the momentum. Okay. Number three, and this is actually what Ted used in his closing argument that David wrote about in the book. David writes a chapter about Ted's closing argument. Ted writes a chapter about David's cross-examination, and otherwise the entire narrative is third person. But in any event, David Blankenhorn, and this was Ted's final line in his closing argument, which was a beautiful closing argument, I must agree with that, that the principle of human equality and dignity must apply to gay and lesbian persons, and we as a nation would emphasize more American on the day we permitted same-sex marriages than we were on the day before. That was the final testimony of David Blankenhorn. He then subsequently recanted, in a sense, in a lengthy piece in the Wall Street Journal or New York Times.
New York Times.
The New York Times, an op-ed, where he believes he was wrong. He has completely turned. He even has gone so far as to say, to quote Solzhenitsyn, and say that the line separating good and evil, the line between good and evil does not separate you from me. It's a line through the heart of every one of us. Pretty profound stuff that he's. So
I will. Can
it
I
took
add?
a lot of courage to do that. We applaud him. Please.
This was the one expert that there was an expert on political science, but it's not too important for this discussion. This was the one expert on marriage that the defendants of Proposition 8 were relying on, and they cited him again and again in opening statements and questions and answers to the judge. And so he was the heart of their case. And so through David's very skillful cross-examination, plus the honesty, I have to give it to him, of the witness, he was brought to make these conclusions that children being raised in gay and lesbian households, their outcome is just as good, in some cases better, and that we in this country would be more American the day we acknowledge the right of gay and lesbian citizens to get married. Now, for those of us who are bringing this case to try to prove precisely that, to have the expert witness on the opposite side of the case say that. I mean, this is those of you who practice law, this does not happen very often. It happens, I think, once in a while if you have David Boies on your team. But even then, it's pretty remarkable. So it was a pretty compelling, dramatic event during the trial.
It was another, what I call the pin drop moments, when you could have heard a pin drop in that courtroom. The courtroom, if I could draw a picture for you, was just amazing in the contrast, almost chiaroscuric in the sense that our side was jubilant, because most people on our side, if you can imagine like a chapel with the bride and the groom side, our side, the pro-marriage equality side, packed every day with people jubilant, and couples, many couples who came up to us after had been together for decades. Two men sat in the back, had been together for 60 years,
Well,
50
45,
years?
46 years, at least
They
if
were right
we're
around
thinking
60
of the
years
same.
old. They had been together. They were soulmates from
They
the beginning.
said, I have to say this, that they were there in line in San Francisco every day, and they were older citizens of San Francisco, and they had been together for, I don't know how many, 47 years or something like that, and they would thank us every day.
Every day.
That we walked into that courtroom, and they stopped me one time. They said, halfway through the trial, we've been together for 47 years. We never thought we would want to get married. But if you win, we're going to do that.
And there were many similarly situated couples, all holding hands and jubilant and happy and joyful and grateful. It was just amazing energy on our side. And then the other side of the courtroom was dark. It was strange. It was really a sense of darkness over there. Because you could, especially after David Blankenhorn's testimony, they had no case. And I'm sure they had to struggle with that. So do you agree with me, Kris and Sandy, about the energy in the courtroom? I was sort of sitting in the middle of it, so I felt it every day. It was just incredible.
Well, we were trying to send negative vibes to the opposing counsel, quite frankly. I'm like, giving you bad karma here. You better not win. We have to win this case. It was an interesting conflict, and there were a couple of, actually a few really hysterical moments in the courtroom. I mean, not only did we get, of course, to see David Boies reduce these witnesses to just, they just looked like an emotional wreck after about 5 or 6 hours of cross-examination. And I remember telling Kris, I said, the Rolling Stones song, "You Make a Grown Man Cry," that is David Boies' song. He makes grown men cry in court, in public, and that's a humiliating bad day for anyone. But it was amazing to see Blankenhorn switch on totally do a turnaround the testimony. It was amazing to see some of the folks that came in support of the opposing side. I remember one day, one of those people decided to take their shoes off and put their feet up on the back of the bench, and we all looked over and said, "This cannot be happening in a court of law. Who does that?" And we all had a good laugh out of that. But we could not have been more, felt more supported by the citizens of San Francisco, because not only did people show up to the courtroom, they lined up for hours to try to get in that courtroom. And then there was an overflow room for them to watch a live video feed if they couldn't get inside, because the courtroom's really not that big. It doesn't hold that many people. So every morning we walk in, there'd be people cheering for us, and just a few people, further away that weren't cheering, but we ignored them. And it was largely a very positive experience.
In the overflow courtroom, which was one floor up, they could applaud and laugh, and you couldn't do that in the courtroom when the case was being tried. But it was more like in a theater upstairs. We heard about it. All this we didn't hear it in the courtroom, but we heard about it later on.
It sounded fun.
Yeah.
The day that the final day was June 12th. So we had the trial, and then the judge postponed the closing arguments for various different reasons several months later. And you and David had time to really master the material. Ted, I think only you presented the close for you. It was an hour and a half long. It's described in the book pretty well. But I have to tell you this, because Ted won't tell this story, that and he used your testimony. Of course, Kris and Sandy's testimony was the most profound evidence. And
Jeff and Paul.
And Jeff, of course, and Jeff's and Paul's. And I'd love you to read a passage from Jeff's and Paul's later if we have time, Ted. But when he presented that and he recounted that testimony and even used video in the close, you could use video for that, ironically. And then you summed it up. Now, again, by that point, David Blankenhorn had kind of turned, and just the emotion and the heft and of what you said, and it was, I think, what Kris said earlier, you really rose to a high place. David Boies is not prone to exaggeration, and he said it was the best closing argument he'd ever heard in his career, ever. And I believe David. I don't think I'd Ted in any event. So I want to paint that picture for you. There's so much emotion. People are trying to keep it at bay in the actual courtroom. Judge Walker dismisses everyone, says his final remarks. We all heard out of the courtroom, all the reporters and the people and the throngs, and we ended up getting herded into the freight elevator. I don't know if you were present then, but as soon as the freight elevator closed, and there must have been 35 people squashed in there at least, maybe 50, everyone broke out in spontaneous applause because you were at the back of it, the car. It was the elevator car. It was pretty amazing.
Of course, they had to be standing, so it was a standing.
Should we let him get away with that?
Yeah.
Should we let him get away with that?
I also think there was for both of you as attorneys and in and out of courtrooms your whole adult life, your entire career, to be a lay person going into a courtroom and to be somebody who's lived with lots of stigma and discrimination, this was very profound for me. I remember that day feeling as if there would be a fair and just outcome to this process someday. Maybe it wouldn't be Sandy and I and Jeff and Paul, but another couple in another state. This was going to work because we had lost at the ballot in California, and that's a very painful thing. We had watched our friends in neighboring states go down in defeat. And really, I had become quite pessimistic and jaded about the system, and I wasn't very patriotic. I'm sort of the opposite of those things. And I remember walking into the judge's courtroom, and it is a very austere environment, and it's just these pews, and then there's an area for the attorneys, and then there's a dais, and the judge sits there, and then above him is the seal, the United States court system seal, and that is all there is. And I remember just being so honored and privileged and moved by the experience that I really, frankly, couldn't believe some of the nonsense that was going on over here, but I thought, how unfortunate that you have these rights and privileges and you're mocking this environment and this system by behaving this way, and I feel like I'm the luckiest person in the world to be here with Ted and David and Sandy and Lady, and we all took it so seriously that it was a huge breakthrough that we were even in a courtroom talking about lesbian and gay discrimination and hate crimes and how harmed we were by not having benefits for our health and our retirement and our old age. All these things were being held from us, kept from us. And what's very ironic, ironic to me at that time, was that I was a state of California government official running a state agency, and I was reporting to the governor's office. And the case is Perry versus Schwarzenegger, but I was the plaintiff and he was governor, and he didn't even come to court to defend it. It was interesting to see just all the chips fall and all the people take their places. And at the end of the day, the lesbian and gay people that came to that courtroom were so honored and privileged to be there because it had never happened before.
Incredible. And we've already forgotten, I think, 5 years ago, even opinion polls were unfavorable to marriage equality. I think by a margin of 17 to 20 points, and that has flipped. That 17 to 20 points now has completely flipped in just a few short years. Fascinating. And I want to point out also that, Kris, that you have worked on behalf of children in the state of California all your career. So I can only imagine how you were feeling when some of this testimony and also they revealed what the advertising campaign had been in California, which was that's also covered in the book and is pretty startling and amazing.
The Protect
the Children campaign. That's what it was called. Now, I know that I'm aware that there are plaintiffs in the Florida cases in our audience. Are you in the front row? We'd love to hear from you. We'd love to open up the entire room for Q&A, but we'd love to hear from you as well. I know your state's in a state of flux. You've had state court opinions that are favorable, and also the federal court opinion favorable to the issue that's being appealed to the 11th Circuit now, I believe. So if you have questions for our team here, we'd love to hear from you. Yes?
You mentioned somebody who's been together for 47 years. We're 52.
Yeah. Excellent.
We recently got married in New York, where we kind of grew up. Chuck and I grew up there, and we met there actually July in 1963, July 4th, actually. And I'm just curious to know what you think the reason was that this recent group in the 5 states came down on the other side, and what arguments convinced that group to
So I will try to answer that in somewhat brief form. The United States federal judicial system is divided up into districts, they call circuits. So there's a certain number of states. This is the 11th Circuit down here, and in New Orleans it's the 5th Circuit, and Texas, and New York it's the 2nd Circuit, and California and other states around California, the 9th Circuit. So and David and I also handled the case in challenging the Virginia law that prohibited marriage between persons of the same sex. And we felt, this was after we finished with Kris and Sandy's case, after the Supreme Court was finished with that. And we thought it was particularly ironic. I will digress and say, here's Virginia, the home of Thomas Jefferson and James Madison and Patrick Henry and George Washington. And that is a state that's still denying people the right to marry the person that they loved. It was also Virginia was also the state of a case called Loving versus Virginia, which was decided in 1967, in which the Supreme Court finally struck down the laws of 16 states that prohibited persons to marry someone of a different race. At any rate, the Virginia's in the 4th Circuit, and we won that case in the trial court and in the Court of Appeals for the 4th Circuit. Other lawyers had handled cases in the 10th Circuit, which included Colorado, Utah, and states out in that area. Other lawyers had handled a case in the 7th Circuit, which included Illinois and Wisconsin and a couple of other states. All of those courts of appeals had decided in favor of striking down on equal protection and due process grounds discriminatory laws against gay and lesbian citizens. The 9th Circuit out in California, where we were litigating, also had come down with a decision. The Supreme Court, we were all sort of hoping, well, the Supreme Court is going to take one of those cases and finally decide this on a national basis and eliminate the problems that exist by having different laws in different states, in different part of the United States, so that if you get married in New York and come here, you're treated differently and that sort of thing. The Supreme Court in October decided to surprise many of us by deciding not to take those cases, as if they were thinking, well, everything's going fine, in the right direction, what's the rush? Now, I think the rush is significant because you've heard about the discrimination that's taking place. I think it's intolerable until we get this resolved as a nation. But the Supreme Court didn't take those cases. And then the 6th Circuit came along, which includes Kentucky, Ohio, and 2 other states. And that case came out the other way on a 2-to-1 vote of 3 judges in the 6th Circuit. And the question is, why? You know, I mean, all these judges, all these district judges, all these appeals court judges, we call them circuit court judges, have been going pretty much all the same way. What happened in the 6th Circuit? Well, each judge in these courts are appointed by different people, and they have different philosophy. But I think, everybody thinks now that the Supreme Court will take that 6th Circuit case, because there's now a split among the circuits in California. Not only do you have different laws in different places, but you've got judges upholding some laws that other judges have struck down. So we think the Supreme Court will probably take that case. But you ask why? You know, what was the rationale for the judge to write that case? I thought it was interesting. He's someone I know, and he's a very, very smart person. He's a conservative. But I thought he might be persuaded by what is happening all over the United States in the Supreme Court, in the defense of marriage case, and these circuit court judges, but he wasn't persuaded. And his opinion comes down to 2 things, which I think is rather revealing. He didn't really quite say that individuals don't have this constitutional right. That's in the opinion. But he basically said that a decision way, way, way back before a lot of the Supreme Court law has come down favorable to the positions that we've been advocating, that the Supreme Court decided not to take a case. They just affirmed it without, it was called summary affirmance. They just said, there's no federal question here, so we're not going to take that case. Well, the judge in this Sixth Circuit case basically said, well, that's still binding on us. Until the Supreme Court takes away that precedent, we have to follow that law. Now, all these other judges throughout the United States had said, no, the theoretical underpinnings of that decision have gone by the wayside, if you read what the Supreme Court has said in all these other cases. So those other judges passed that by, but he rested on that, which sort of allows him to follow precedent without explaining why those decisions that we rely on are wrong. And the other thing he said is that this is not a question of what gets decided, but who gets to decide. What about all the people that voted for these laws in these states? And I was somewhat staggered by that, because that is, by the way, why we have judges, and that is why we have a constitution. And so judges, like they did in that Loving versus Virginia case to strike down discriminatory marriage laws involving people of different races, that is why you go to court. Judge Walker asked me that question several times, or at least 2 or 3 times during the trial. People of California voted, don't we have to defer to the people of California? And I gave somewhat similar answer to him that I gave today. That is that we have constitutions, we have an independent judiciary, we have a Bill of Rights, because the majority doesn't always follow the Constitution. The majority rules against minorities. And I put it to Judge Walker, I said, that is why you are sitting there. That is why we have you. It is your job. It is your responsibility. Some judge is going to have to decide that. You'll never have a better record. This is the case. And so I was a little disappointed with the judges in the Sixth Circuit that came out that way, and I hope that that'll be turned around.
If you'd like to feel better about that opinion, then, thank you, Ted, then you should read the dissenting opinion by Martha Craig Daughtry. I don't know if anyone's read that. It's absolutely beautifully done. It's searing, gets right to the points Ted was just making, and it describes Jeff Sutton's majority opinion as analogous to a TED Talk. That it could be an introductory course to political philosophy. It's, they're sort of hiding behind these precepts that are so abstract about separation of powers, because he's hiding behind and not dealing with the issue that involves human beings. And she really drew a beautiful analysis of that. Yes, please.
Well,
He essentially is kind of referring that then to the Supreme Court in a way of getting himself off the point and moving on.
It's an intriguing theory, yes.
It's sort of you could put it that way. I mean, he found a way out, which was, I think, pretty thin gruel. This gentleman here at the
Yes,
microphone.
please.
Yeah. By the way, her first paragraph is incredible in her dissent in that Sixth Circuit case.
Absolutely.
If only you could read that. A question for you, though, about Judge Walker. Isn't there a little backstory there about them trying to recuse him? And could you talk about that and tell us why?
Yes. Do you want me to address that, the Judge Walker
Please.
issue? Judge Walker was appointed originally by Ronald Reagan to the district court in San Francisco. He was a Stanford Law Review. At top of his class, he was a partner in one of the big firms in San Francisco. He was actually opposed by the liberals, including Nancy Pelosi, because he had defended the United States Olympic Committee against the gay Olympics. It was a trademark issue, but they thought, well, that reflected prejudice against gays. But it was somewhat of an open secret in Northern California that he himself was gay. He had never come out of the closet, but he never really disguised who he was either. So when the case was assigned to him, and these cases get assigned by lottery in federal courts, they spin a wheel or draw the initials out of a box or something. It was completely at random. He was the chief judge by then of the federal court in San Francisco. Highly respected. He'd done all kinds of cases, but he was gay. So we knew that. And we were wondering whether our opponents was going to object. We felt that it would be totally unacceptable to object. A gay person who's appointed by the president and affirmed by the Senate to be a member of the judiciary is entitled to deal with legal questions that come before him or her. Justice Thurgood Marshall, one in the Supreme Court, had been one of the most fiery advocates in America for civil rights, for African Americans, and he then was Solicitor General, and then he was on the Supreme Court. He decided cases involving race. Ruth Bader Ginsburg was a heroic champion for against gender discrimination. That was one of her passions. She argued cases in the Supreme Court on behalf of women's rights. When she went on the Supreme Court, no one said, well, you can't discuss cases involving pregnancy or, you know, issues involving women. So it was sort of demeaning to take a position that Judge Walker couldn't be fair on the issue of gender discrimination or sexual orientation discrimination. And they didn't raise it until they lost. Once they lost, then they filed something in the court saying, well, he should have revealed to us. He should have said that he was in a relationship with another man, and that he would therefore benefit by possibly getting married in California. Well, the new chief judge of the district court dismissed that. And I think all the judges on the district court in San Francisco, I haven't asked them, but I think that they were probably offended. This was one of their highly respected peers. And that motion was also rejected by the United States Court of Appeals for the Ninth Circuit. I think it was an important development in a way, because it was also an important judicial decision about the rights of gay and lesbian individuals. You can't say that because of your sexual orientation there's all these classes of cases that you sort of have to take yourself out of. So I think that was an important civil rights victory as well. I'm glad you brought that up.
Good point. And we have a question?
Yes, sir. My question is basically to the panel in general. We learned from Mr. Sutton, Anthony Sutton, which wrote a book, America's Secret Establishment, that one of the regular initiatory rights that Skulls and Bones has is to recite their sex line in a coffin, which means that when they're reciting the sex line, they're reciting the bloodline, which is a ritual that law enforcement uses in order to maintain law and order, bloodline, sex through bloodline. It is not a secret. Now my question is, what prevailed in the Supreme Court? The will of the state or the will of the human condition?
Okay, so I think the Supreme Court has got a long history. First of all, we start with the proposition that governments don't create rights. Individuals create a government. This is one of the things that differentiates this country from a good part of the world. There's a culture in other parts of the world, or political values in other parts of the world, that governments will give you whatever rights there are. Chief Justice Roberts and Justice Scalia and other justices have said the thing that makes this a strong country and a strong constitution that's endured all this time isn't so much the Bill of Rights. One of the most impressive bills of rights that have ever existed, and Steve Zack has talked about this too, president of the American Bar Association here, is that the Soviet Union had a really fabulous Bill of Rights. It didn't mean a thing. Iraq had a great Bill of Rights. What distinguishes this country is the separation of powers and an independent judiciary. And so the founders of our Constitution wanted a Bill of Rights because they wanted to make sure that that was in there. But what protects that is the independent judiciary. And to go back to your question, what the Supreme Court has done again and again is saying, these are rights that we believe, and you go back to the Declaration of Independence, We believe that these are inalienable rights of all citizens, and governments are created to protect those rights. And so I can't get into all of the details of that, but I think it's important that we have this kind of a system in this country.
Very good. Do you have a question? Yes, please.
It's really a quick remark that I'd like Mr. Olson to react to. Notwithstanding your criticisms of the disappointment in the Sixth Circuit's decision-making logic, wouldn't you say, though, that it'll help the country move expeditiously to a new plan in human rights? Because now the Supreme Court, Scalia and company, the Supreme Court can't duck it. And this could have dragged out for another decade. Who knows how long, circuit to circuit, and with a patchwork of different opinions addressing different legal constraints upon the rights of gay and lesbian, human rights issues. So in some sense, maybe your old conservative pal who you're disappointed in has really done the country a favor. I just put that as a statement for reaction or something.
Okay, I'll make it brief. Yes, I agree with you. I mean, in the other cases, the Fourth Circuit case, the Seventh Circuit case, and the Tenth Circuit case, the lawyers who had won, including us in the Fourth Circuit, wanted the Supreme Court to take this case in order to get a clear national understanding of the rights of gay and lesbian citizens. Not having taken the case, now that I thought the Supreme Court was going to have to do it because it's intolerable for people to live in Mississippi and not have rights because that they were given when they got married in New York or something like that. But I think you're right. Most people that I've talked to, it's not unanimous, but most people think that the Supreme Court has to take it now because there's this split in the circuits. One or two voices are out there saying that they're just don't want to get to the issue and don't want to decide it. I want to believe more in the Supreme Court than what I think cynics believe is that they're afraid to get into the issue because it'll be too controversial and there'll be backlash and things like that. I don't believe it. I think it's their job. I think they have to do it, and I think they will.
Very good. Is that the end of the program? It can't be the end. Sandy, I have a question.
There's another question.
Okay, yes, but please, I'll take
I'm just curious how you and David Boies became involved together on this case.
I will answer that. I didn't want to take. We're up here with this whole case is about, and I think that's a fun subject, and I will address that. The case is about the individuals, Kris and Sandy and Paul and Jeff, and that's why that was so important in our closing argument. That's why they were the first witnesses in the case, because we felt that putting them on the stand and having them to describe their life and actually making people think about discrimination and the day-to-day lives of individuals who are discriminated against, that was all it was going to take to win the case. But David, it's a great story. David and I were opposing lawyers in Bush versus Gore. And David and I have a similar background. We are just about the same age. We're exactly 6 months to the day. I'm the older one, and David's a little bit younger, but he grew up born in Illinois, grew up in California, and then he went to New York to practice law, and I went to California to practice law. But I was aware of him through his reputation and so forth. During Bush versus Gore, which of course took place where? Florida. We spent most of our time in Tallahassee, but we came down here a few times to be in court. I was an enormous admirer of how he handled it, how professional he was, and how the team, and how persuasive he was. Part of our job during that litigation was to get out in television and explain the position of our clients, because our clients wanted the American people to understand why they felt theirs was the right thing. David was talking about count every votes, and I was talking about do this according to the rules that were set before the election. Don't change them in the process of counting votes. But it was so. I was watching him. I was seeing how persuasive he was. After that, I won't. It's a longer story, but we explain it in the book. we became closer and closer and closer together. And we, Lady and I, and Mary Boies, who's also a lawyer, and David, we would get together from time to time to have dinner, drink wine, go bicycling in Europe, and do various things together. And we kept thinking, what if we were on the same side? Couldn't we really have fun if we were lawyers on the same side? And how could we possibly lose? And so when I was first approached about this case, I thought, because I was a conservative and well known on, and I might be suspect, and I thought it was very important that the American people see this as not a Republican or Democrat issue or a conservative or liberal issue. We felt that it was important for the American public to see this as an American issue, as a civil rights issue. Thank you. And so it was important for the two of us from opposite ends of the political spectrum to present that unified front with respect to the constitutional questions. We also thought it was exceedingly important to try to change, in whatever ways we could, the public opinion, so that if our clients won in court, the American people would say, yes, that's right, that's finally a right result, like people do feel now today, by and large, about interracial marriages. So we went out to convince the public. We went on television, we wrote articles in magazines and newspapers and things like that. And the fact that we were thought of as an odd couple coming together was a novelty. It wasn't so much a novelty as most people were thinking. We thought it made perfect sense. We decided, one little piece here, David would win the justices that he got voting for him on behalf of Gore, and I'd win the other ones.
Honey, you're getting away with too much here, okay? No, time out.
So-
the moderator's got to step in.
So anyway, we got together and we
Continue.
decided we'd form this team, our two law firms, which work seamlessly together, and put all of our resources into that. It's very hard for the individual lawyers to put the kind of resources that Boies, Schiller, and Flexner, and Gibson, Dunn, and Crutcher were able to bring into this case. And we were going to have a public forum which we could talk about how important these issues were. So that's pretty much how it
Kris and
went.
Sandy can speak to how many lawyers did you?
Yes.
I mean, it was how many?
Well, 60 or 70
Every
maybe
day.
by the time it was all said and
Incredible.
done. During trial, it was at a peak, wasn't it? It seemed like they were everywhere. And it's very reassuring when you're pulling up the kind of evidence that you are. It's video, it's transcripts, it's books, it's articles, just the volume of material that each expert witness was attached to that you had to be familiar with in order to get the testimony into the record. I mean, it was really spectacular to watch the coordination between those of you in front of the judge talking and everybody behind you and what they were teeing up. And is sitting in the front row with you, lady, we were just sort of watching, it all unfold in a way that was really
Stellar lawyering and some Supreme Court clerks, but formerly Supreme Court clerks, people who had were gophering and running errands and compiling. It was such a beautiful thing to see, and I think it's important to point out here too, by the way, that David's firm gave entirely his effort entirely without cost, and Gibson Dunn gave about 3/4 of their time with pro bono. Yes, did you have a question? Yes.
Maybe it should be the last one. I don't know who's rationing the time, but maybe this should be the last one.
I think it's an unlimited time.
One more,
So,
Tom?
all right,
Okay.
please.
Our leader.
We on? Okay, thank
Yes,
you,
dear.
Mr. Olson. I had a question. The media has often referred to you as a movement conservative who led this effort through the California Supreme Court and the U.S. Supreme Court. I was wondering if there were other conservative allies you had that would be known in this effort. And also, the other question I had was there ever a log cabin Republicans versus the state of California filing that you're familiar with? And if there was, can you tell us about it and your relationship to log cabin Republicans?
Well, I've always felt that marriage is a conservative value. Two loving people coming together to want to form a part of the community and form an enduring relationship and raise a family, that's a pretty conservative value. And I wrote something that was in the cover of Newsweek magazine called The Conservative Case for Gay Marriage. Libertarian individuals who are part of the conservative movement in this country are very, very strongly in favor of our position in this case. The Cato Institute, which is probably the most conservative libertarian organization in the United States, has been supporting us. More than that, what's happened over the 5 years that we handled this case is that major corporations decided that this was the right thing for their company. When we started this case, there was probably no major corporation who would want to touch it because it was just controversial, not because they had a negative or affirmative thing. By the time we got to the Supreme Court, something like 50 or 60 of the Americans' leading corporations, from Microsoft and Google and on down, were filing briefs in support of us. Leading Republicans filed a brief in support of the case. We had civil liberties organizations, and we had professional football organizations supporting us. So we were building a coalition all the time. And to get to the gist of your question is that I think that it is exceedingly important for people, once they start talking about these issues, to understand these issues and it manifests in some way their support. We were last night in Dallas at a magnificent event put on by the Human Rights Campaign and a group called Black Tie Dinner. And they were given an award to a broadcaster, a sports broadcaster, when Jason Collins, the basketball player, came out, and he was there too, and explained, his coming out. But this sportscaster was one of the most popular persons in Texas, and came out and said, "Yes, it's okay. It's sure we respect him." And then the deluge of support for him because he was willing to take a position like that. He surprised some people, but it was 100,000 tweets in 6 minutes or something. I mean, I don't know what the numbers are, and I don't know what tweets are, but...
Do you have any question, dear?
Yes. Could you give us a better understanding of the U.S. Supreme Court rationale in coming to its decision?
I didn't hear the last.
The rationale in making the decision.
Oh, well, the Supreme Court is taking the position, we hope, and it said in the defense of marriage case, that discrimination against individuals because of their characteristics, of their sexual orientation, is demeaning to individuals, is discriminating against a class of persons who are what they are because of the way that they were born and the way their makeup is. And it's on the same plane as discrimination on the basis of race or discrimination on the basis of sex. And it hurts the people that the discrimination is against. And it does no good to deny Kris and Sandy the right to get married. Does not help or preserve heterosexual racial relationships or marriages. It doesn't cause people all of a sudden not to get married because they're heterosexual. So that's a very brief summary. You wanted to wrap this up in some way.
Yes, we have one more question, and then we'll wrap it up.
Hi to the two mothers. I am a trainer for issues of my sexual minority children. I would like to hear from the two of you, because our children tend to get lost in these larger systems, how these things affect them. And perception is huge, and we know that. How did the discrimination, harassment of you affect your children before, your 4 boys, and how has it affected them since?
Great question.
Well, the good thing about where we were, and one of the reasons that we agreed to be in the case, was that our kids were kind of growing up. So at the time that we joined the case, one kid was in college, one was about to finish high school and go to college, the other 2 were in 8th grade. By the time we finished the case, the younger 2 were in college and going to college. So that's how long it took. But because the kids were fairly old, we felt less worried than we would have been. We probably would not have joined the case at all had we had young children. It would have been too intimidating. But our kids became very protective of us, and it was a very sweet thing. So they were very aware that it was going on. They, answered the phone when somebody really, a crazy person called. It was crazy, true. But they became very protective of us and would say, do you want me to walk to your car with you? And would you like me to come and, pick you up from work? I mean, because they could drive. So I think it brought that out in them, and it helped us see them in a different light as well, which is lovely. But I do want to tell a really sweet story about when they were younger and the kind of community we lived in. We live in a very progressive community. Berkeley, California is like way out there, right? Which is why we live there. No accident. But even in Berkeley, California, when one of the little boys, the twins, I call them the little boys. They're all over 6 feet tall, but to us they're little boys. When one of the little boys was in kindergarten, this new boy came to town and came to school one day, and it was when Kris was there doing reading time, circle time, and the teacher introduced Kris as Elliot's mom. And this little boy said, "Wait, your mom was here yesterday," meaning his other mom, not me, but his other legal mother. I'm the stepmom. And he said, that can't be your mom. And Elliot said, I have two moms. He goes, that's not normal. You can't have two moms. And the teacher stopped the class and took it as an opportunity for like a learning session, said, whoa, we're going to stop right now, our reading session, and talk about families. Everybody's family is different. Some people have two moms, some people have two dads, some people have a grandma, and that's their family. Some people have adopted siblings, all kinds of families in all kinds of shapes and sizes. So our kids had grown up with the benefit of this community, and it helped them tolerate much better some of the backlash that we did in fact encounter. But they were protective of us, to every single one of them, and I think they felt very proud of us, which was a lovely thing for us to get to see them feel proud of us, because we were used to them think we were just nagging mothers, We're like, my God, please leave us alone. So it was kind of a nice change of events.
Well, I applaud you all. Most children are not able to grow up in that type of community, including here in Miami, because the harassment, the bullying is just notorious, and we just need more of the adults to handle it the way that teacher did.
Sandy talking about their children reminds me that another beautiful thing about the longevity of our own personal effort in this, we had a 5-year window in this long journey for marriage equality, but it enabled us to get to know these wonderful people here on this stage, which we've been calling plaintiffs for 5.5 years, and we've just got to find a better word for them than that.
Okay, Tom's who?
So please, yes, Tom.
So that's it for this.